over decades to come. We meet today at a crucial inflection point in human history. As we speak, geopolitical tensions are simmering, economics are being stressed by their breaking points, markets are on a free fall, resulting in a commercial uncertainty and disputes. But perhaps most significantly, there is an increasing sentiment of institutional fatigue, a growing sense that our traditional mechanisms of justice are perhaps struggling to keep pace with velocity of modern conflict. We are witnessing a paradigm shift where the old command and control concept of law is being tested by a globalized world that moves much faster than a court calendar. In these circumstances, can we afford a stick to adversarial dispute resolution instead of embracing the era of problem solving? First, I will say evolution of disputes resolution. As we embark upon a discussion about dispute resolution and the future of law and the role of courts, arbitration, mediation, and technological advancement shaping the future of justice system globally, in order to understand dispute resolution, we must first define the problem. What exactly constitutes a dispute? Every dispute begins with a gap between the expectation and reality, a perceived injury. In the foundational wisdom of Indian scripture, we find Sanskrit principle that Satyena Rakshet Dharma. Truth protects the law and or the dharma protects the truth. The Supreme Court of India, the most consequential apex court in the world, guardian of the aspirations of the largest democracy over 1.4 billion people, has adopted a similar principle in its motto, reminding us that victory is not the trump of might, but inevitable crowning of dharma. It is motto is yato dharmas tato jaya. Where there is a dharma, there is a victory. Truth is the tool which sustains dharma, and the path of dharma is what leads to jaya. The ultimate victory, which is no longer just about winning a case, it is restoration of balance. Dharma is alignment of reality with justice. Then a dispute is the fracture of that alignment. When the truth of one party no longer aligns with the truth of another, a claim is made and it is rejected, is when dispute is born. Now, here the role of courts come. In the journey of the adversarial to problem solving, however, the courts will continue to stand as ultimate guardian of rights and the rule of law. But they can no longer be viewed as the only source of justice. Development of multi-modal dispute resolution system is perhaps the best decision we can take for our progeny and for future. This evolution of justice from litigation to resolution requires a concerted effort from all of us by approaching the understanding of courts as an essential service instead of physical location. Professor Frank Sander, Harvard Law School, way back in 1976 proposed what he called a multi-door courthouse model. Back then, it was viewed as a radical academic proposal, but it has come to a blueprint in 21st century justice. where cases are screened at the initial stage and routed to the most appropriate process, whether mediation, arbitration, neutral evolution by conciliation, or traditional litigation. This ensures that the resolution mechanism fits the specific needs, costs, and desired by the formality of the parties involved, while so ensuring that justice is not delayed. This is the need of a party-driven dispute resolution where parties retain a great level of control over their own fate. And is enabling this, the courts of the future must not merely be arbiters, but rather they must be the directors of justice, truly getting to the core of dispute and understanding the best approaches to resolve it. Now, coming what may be a role of idea in the future dispute resolution. Alternate dispute resolution is said to be future of dispute resolution. But I truly believe that it is now, India has witnessed a paradigm shift in the 21st century, and wherein the various mode of dispute resolution have become appropriate rather than merely being an alternative. While courts and traditional justice delivery system shoulder the constitutional responsibility of interpretation of the law or application of law and to resolve interpersonal disputes, the ADR process offers parties the flexibility to arrive at solutions which meet their unique requirements, needs, and interests. Lack of rigid procedural shackles, which are usually a limiting factor in litigation, makes the mediation process more accessible to the parties. Unique sense of collaboration in area also allows a party to preserve their relationship, be it familial, business relations, or between neighbors. The mediation process encourages parties to be hard on the problem, not on the person, which helps parties recognize that they can work together to solve the problem at hand rather than seeing each other as the problem. Now, coming to the arbitration, our jurisprudence today recognizes a fundamental truth. When a party chooses the arbitration, they chooses finality, and court must respect that choice. Arbitration has become a preferred method for resolving commercial dispute at a global scale. With the increasing use of resolving labor disputes, environmental disputes, and other disputes, the International Chamber of Commerce, ICC, reported a record high total case load value, 354 billion, by the end of 2024, involving parties from 136 jurisdictions. Our Domestic Law Arbitration Act 1996 codifies minimal intervention as a letter of law in Section 5, which contains a powerful non-obstante clause stating unequivocally that notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except so provided in this part. With the recent Constitution Bench judgment, Central Organization for Railway Electrification versus ESI, popularly known as Court 2, India has become one of the first jurisdictions globally to delegitimize unilateral arbitration appointment. The majority judgment reasoned that such clauses violate principle of equality and equal treatment of parties enshrined in Section 18 of the Arbitration Act and cast justifiable doubts on the independence and impartiality of arbitrators. The court held that even though party autonomy is fundamental tenet of arbitration, requirement of fairness and impartiality are also sacrosanct. India is positioning itself as a sophisticated, cost-effective, and neutral alternative and traditional Western hubs of arbitration. With rampant economic growth and increasing inflow of foreign money, India is rapidly overhauling its legislative framework of transition from litigation-heavy culture to a pro-arbitration regime that mirrors global best practices. The Indian judiciary, particularly the Supreme Court, has made it clear and concise shift towards party autonomy, respecting the sanctity of the agreement to arbitrate between the parties, minimal judicial interference, restricting the scope of reappreciating evidence or treating award as subject for appellate review, the separability of clauses, even if contract is challenged, the promise to arbitrate remains as sacred and independent, finality of arbitral award, ensuring that the end of the matter is indeed the end. Coming to the mediation is currently experiencing its New York Convention movement, though the implementation of the Singapore Convention on Mediation. By providing a uniform legal framework for the cross-border enforcement of mediated settlement agreement, the Convention removed one of the primary historical barriers to the use of mediation in international commerce. The fear that settlement reaches in one jurisdiction would be unenforceable in another. In India, we have introduced a mandatory pre-litigation mediation through 2018 amendment in the Commercial Courts Act 2015. The Supreme Court of India in Patil Automation versus Rakheja Engineering has held this requirement to mediate prior to litigation in a commercial suit is a mandatory requirement, and non-compliance must be met with rejection of the plaintiff. We have codified our Domestic Mediation Act. Although most of the sections are not yet notified, yet a visionary law, its intent is explicitly articulated in the preamble to promote and facilitate mediation, especially institutional mediation for resolution of dispute, enforce mediated settlement agreements, provide for a body for registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective. The key introductions such as granting mediated settlement the same enforceability as court degree, given them legal force and ensuring parties negotiate seriously. Second, protecting confidentiality of discourse. And third, embracing online mediation collectively create a secure and accessible and modern framework for dispute resolution. With the advent of online dispute resolution, ODR, the technology is great equalizer of the future, increasing access to justice and ensuring that justice reaches those who are located at the remote parts. The greater challenge globally, however, is to ensure that virtual sessions comply with high standards of confidentiality that online dispute resolution mandates. Intermingling to process of arbitration, mediation, arbitration, dispute resolution clauses have also undergone insignificant development with time, with innovative multi-tiered dispute resolution clauses being introduced in contracts by parties in exercise of their autonomy. The practice such as arbitration, mediation, arbitration is the best example of evolution of the dispute in future. The human ingenuity has led to us such innovative ways to resolve dispute. Section 30 of our Indian Arbitration Act provides so. This model truly is the best of both worlds, since it offers the procedural certainty of arbitration along with flexibility of mediation, a powerful combination of complex disputes. Now, coming to the conciliation, which is not a part of this, but I feel it is one of the proactive mode. The conciliation serves as a proactive bridge between the neutrality of mediation and finality of arbitration. It empowers a neutral third party to go beyond mere facilitation by actively proposing an agreement when a compromise is in sight. Earlier, conciliation was governed by Arbitration and Conciliation Act, while under new Mediation Act, the definition mediation includes in conciliation for all intent and purposes, making even more robust. Where a mediation or conciliation fails, the binding arbitration process serves as a trustworthy mechanism to resolve disputes. A pertinent example arose before me recently when a municipal corporation versus Greater Mumbai reported 3 days back in a judgment I authored and delivered day before yesterday. The court declined to set aside the arbitral award, affirming the sanctity of the process of the arbitration. In this sad case, the parties has temporarily held the arbitration is in abeyance for explore a potential settlement through conciliation. The conciliation proved to be non-starter. The parties were delegated on binding arbitration process, which ultimately culminated in a definitive award. There is an increasing realization among parties regarding inherent values and compromise and settlement. This shift in mindset acknowledges that litigation is often a zero-sum game, whereas ADR offers a spectrum of resolution. Coming to the technology and the evolution of justice system, the world generally and India specifically is undergoing a digital revolution at an unimagined scale. While technology moves fast, the law must move with principled deliberations. As the whole world builds and adopts digital infrastructure at scale, the legal profession must ensure that technology remain a servant of the values of justice, not their substitute. With the rapid integration of AI into commerce and governance, we are witnessing a fundamental shift in how automation influences our life and law. AI can optimize decision-making and draft complex instruments, but does it retain the capacity of understand justice? Certainly, AI can draft 100 pages merger agreement in seconds, but it can understand the underlying interest of the parties, their positions, their bargaining power. That human element is what truly converts a 100 pages document into a true contract. What is vital role played by legal professionals in this era, which must be recognized by evolving justice system? Chief Justice of India, Justice Suryakant, yesterday shed light on the initiatives being taken by the Supreme Court to adapt to technology advancement. It's a concerted effort by the Supreme Court of India, which judges collectively acknowledge. In our view, justice involves more than just logic. It requires empathy, discretion, and the ability to navigate the gray areas of human conduct. AI can't see the number of witnesses, will never understand, and plight of litigants. To let a machine substantively adjudicate upon the rights of the liabilities to parties, a distant and controversial goal. A recent survey by White and Case, an international law firm, underscores this hesitation. While 77% of practitioners were agreeable with the using AI to calculate damages, only 23% agreed AI giving decision on merit. However, the justice system must adopt rather than resist this technology interface. AI can serve as an excellent scriber or calculator, making life easier for judges, advocates, and court staff alike. By acting as human in the loop, the legal professional can delegate routine, repetitive tasks to machine while maintaining the vigilant oversight and empathy that only a human can provide. As I look forward to the future, however, I hope that the global justice system in its push towards technology remains cautioned of the inherent risk of uncritical reliance. While AI can process vast amount of data, it remains inept at the rigorous verification of facts. Even dedicated legal AI lacks the scrutiny required to discern the validity of its sources without human oversight. This leads to what people in tech are calling hallucination. This results in automation bias, where judges or advocates may overall trust computer-generated outputs as objective truth, doubting their own professional institution. Furthermore, we must confront the algorithmic feedback loop, because AI is the reflection of the data it consumes. Any existing social or systematic biases fed into machines are not merely mirrored, they are magnified. Without the human in the loop, the break of this cycle, we risk automating the very injustice we seek to resolve. In conclusion, the future of law and dispute resolution is bright and is rest on good hands. The level of innovation and thought which is being put into dispensation of justice is unfathomable. Lawmaking has become increasingly empathetic and cognizant of ground realities. As we stand at this digital crossroads, we must remember that our progress is not measured by sophistication of our tools, but by our fidelity to the values they serve. The values to access to justice, rule of law, and empathy must guide us into future. Let us not meet future with resistance. Let us instead embrace change, the only true constant. As the ancient Greek philosopher says, that a man cannot step into same river twice, because it is not the same river and he is not the same man. Thank you very much for giving this opportunity to me and share my views on today's topic. Thank you.
Well, a huge round of applause for the Honorable Justice J.K. Maheshwari. Thank you very much, sir, for those insightful words. Truly, the future of law is something that he has encapsulated in his speech. All right, shifting our focus to yet another very insightful, interesting, intriguing session. We are talking about the future of legislating the law. And to join us for this discussion, we have Right Honorable Dan Carden, who's member of the House of Commons, United Kingdom. We have Senator Adela Sipova, who's a member of the Senate of Czech Republic. We also have Honorable Rachel Brooking, who's a member of the House of Representatives of New Zealand. We have